Court of Appeals Division 1 is now in session.
Please be seated. Thank you for being here. We're here at 1 CR140470, State versus Horton. Each side will have 20 minutes to do their argument. Appellant, you may reserve any portion of that you want for rebuttal, but you'll have to keep track of that yourself. We are recording the argument, so when you approach the podium, please identify yourself and your client. In a couple of days, the argument should be on YouTube. We've conferenced the case. We've read the record and the briefs, so we're familiar with the case. So when you come up to argue, just begin your argument. Counsel, you may begin.
Thank you, Your Honor. Michael Dew for the defendant appellant. I don't have any speech prepared, and I don't think you want me to repeat what I wrote. This court set sua sponte oral argument, which kind of surprised me, but I'm prepared, hopefully, to answer any questions you have as to what you deem to be important on this that you set it for oral argument.
I'll start with a question.
Yeah.
Two questions. I guess we're interested in your view on the state's alternative argument. But before we get to that, assuming we agree that this is a pretty weak case, why isn't it a jury issue? Your client is holding a gun. Your client hasn't holstered the gun. He's walking away, but clearly the gun hasn't been put away. Even assuming that's a pretty weak case, why isn't it enough to give to the jury?
Because the walking away with a gun is not contemporaneous with the intentional placing of someone in apprehension.
What about just 1 minute earlier, 30 seconds, I don't know, was where he took a position where it appeared that he was holding a gun, facing them. That's not a factor that would go into the equation?
Well, there was no evidence that he was pointing a gun at them, at least from their point of view. The guy thought it was a toy or a wallet or something like that. That's why he put his wallet up on the thing, said, I've got a gun too. Come on over here, let's do it. He was pointing something, I'll grant you that. But you have to have some kind of evidence of a subjective apprehension on the part of the victims in order to be an assault. In this case, an aggravated assault.
So are you saying that it's a missing element? The
yes, sir.
Lack of
yes, sir.
Reasonable apprehension?
Yes, sir.
But all the other elements are there?
I think there's circumstantial evidence of the other elements. I think the element of subjective apprehension on the part of the victims is totally lacking.
We can't consider at all the fact that just a couple minutes earlier, I mean, they saw him pointing something, whether it's his finger, but then they immediately realize that it is a gun when they're up close to him and he's walking away. But if you're saying the element is there as he's walking away, you're saying we have to. Sorry, I'm probably misstating it. You're saying we can't consider that he was pointing a gun at them previously?
No, I think that's probably circumstantial evidence that he had a gun earlier, but they didn't know it.
But they know it at the time he's walking away.
They know it when he's and they go, oh, geez. That's after the fact, Judge. That's what I'm saying. It's not contemporaneous with his intent.
But does it not go to maybe their thought that he's still a danger to us because he's pointed a gun at us and he hasn't put the gun away? Even though he's walking away, he hasn't put it away, so we're still at risk.
Well, the problem you have is the female victim, if I can remember the facts correctly, starts walking over there, says, hi, I'm so-and-so, you know me. And she's doing that. She walks over and okay, and he turns around. So obviously they knew each other. He felt whatever reason he had for pointing the gun, assumably to protect her because they were having a fight. He felt circumstantial evidence of that they knew each other and he wasn't going to do anything. She walks over there, he walks away. I don't know how you could have fear from something like that once you've identified yourself and say, hey, I know you, that kind of thing. And that was in the evidence.
But if they were just trying to calm him down by saying, hey, and we know each other, that wouldn't preclude a finding of reasonable apprehension, would it?
Well, she's trying to diffuse the situation, but she doesn't know what the situation is. That's my whole point. She knows that these guys have been going back and forth for, I think the male victim said 5 minutes, come over here, no, you come over here, you come over, that kind of thing. You know, Mexican standoff, and she's just trying to diffuse the situation, but she doesn't know what the situation consists of other than it may be a fight at some point. She doesn't know that the guy's pointing a gun at her. So she goes over and says, hey, once again, I think that's pretty clear that she doesn't have any apprehension of being shot because no one in their right mind would walk toward a person that you think has got a gun pointing at you. She's just trying to diffuse an otherwise tense situation between her boyfriend and this guy.
So you're saying, Counsel, Mr. Horton did not cause reasonable apprehension, but did he intend to cause?
Oh, I'm sure he did. I'm sure he did at the time.
If he did, then that doesn't that
because
how isn't the state how is there not merit to the state's argument that we should reduce the conviction here to an attempt?
You probably could. The only problem I have with that is that the cases that I've seen where you reduce it in degree is that the jury was either given the option of deciding a lesser included or instructed on it in some way. Here there was no request and no instructions given. So that's the only fly in that argument.
The states waived that argument by not requesting a lesser included, although
I think they did, and you know, both sides waived it. In fact, your cases say that if you present an all or nothing defense, which is what this was, you live or die by that defense. You don't get to have the benefit of something less, and I think it kind of works both ways, does it not?
Well, Counsel, the name is escaping me now. I'm aware of the case because I was involved in a case on appeal years ago, but I thought that it is a case involving trafficking in stolen property. I don't recall that there was an instruction in or an attempt in that case, but the Court of Appeals reduced that.
That I don't remember, Judge. I'm sorry. I'm just saying that for this particular thing, and in the cases that have come down since, there's lots of issues on appeal that, well, the judge should have given a lesser included, and we know that he doesn't have to unless it's in a capital case. And that was a recent one, a Luau case from upstairs, where they said for second-degree murder you have to do it for passion manslaughter. But those cases aside, every other case I've seen says basically if you present an all-or-nothing defense, you can't complain at all on appeal. Neither side can complain. If you don't request it, or if the judge denies it, then you have something different. But if you don't request it, don't present any argument to the jury that it should be something lesser than the full thing, then guess what? You're stuck with either the full thing or nothing.
So if we don't accept your waiver argument, then you're conceding that the elements of attempt are made?
Yes, sir.
Okay.
Yes, sir. Thank you.
Thank you. Mr. Mathias?
May it please the Court, Mr. Dew. I'm Joe Maziarz, Chief Counsel of the Criminal Appeals Section of the Arizona Attorney General's Office, representing appellee in this case. I think there's one thing we can all agree on, and this is an odd case. Factually, it's a very strange case. That said, the legal issue is really very simple and straightforward, and that is whether any reasonable or rational juror could find beyond a reasonable doubt that the victims were placed in reasonable apprehension of imminent physical injury and whether the defendant intended to do so after he put the gun down and was attempting to walk away. That's the issue, period. And actually, this court is in a better position than most appellate courts are, because generally the court has to infer or speculate what it is the jurors found or may have found. But in this case, the prosecutor teed it up for the jurors in his closing and rebuttal closing arguments. He told them, to convict, you have to find beyond a reasonable doubt that after the gun was put down and the defendant was attempting to walk away, he placed the victims in reasonable apprehension of imminent physical injury, and he intended to do so at that time. In fact,
if he's put the, well, I've got two issues with that. First, if he's put the gun down and he's walking away, it would seem kind of odd to say that the act of going away from the tense scene, it shows an intent to put someone in reasonable apprehension. And then my second issue is, if the two victims are following him, that really doesn't show that they're too afraid of him.
2 points. On the first point, clearly, I don't think there's any question, and I think counsel's conceded, when he pointed the gun at them and was telling him, go away, get out of here, he intended to place them in reasonable apprehension. The issue is whether, once he realized that one of the victims recognized him, and he clearly at that point, he wanted to get away, and he didn't want to be followed because they could direct the police to where he lived, and also he was at least it's a reasonable inference that he was fearful of Leonard, the male, because they had exchanged words for quite a while before this. So the fact that he put the gun down and wasn't no longer pointing it at them doesn't mean that the jurors couldn't reasonably infer that he still wanted to place them or intended to place them in reasonable apprehension to make good his escape, so that they wouldn't follow him, so that they wouldn't retaliate. And Leonard expressly testified to that. He said, I was still, even after I realized, even after he had stopped pointing it, when I realized it was a gun, I was still in fear because I thought he might retaliate against me. And on the second, well, on the second point, it appears that Holly followed him for a short distance and Leonard was trailing behind her. The record's not crystal clear on that. As you can imagine, their testimony isn't crystal clear on how far she followed him. She never specifically said, I was in reasonable apprehension or I was afraid. But even reading a cold transcript, it comes across that she was in shock when she realized it was a gun. And I'm sure all of us have been in situations where we don't do the smartest thing in the face of a dangerous situation. Should she have, at that point, stopped and backed away? Perhaps. But again, that's a jury question. And they didn't follow him a great distance. In fact, he was successful in getting around the side of the building. They stopped after they had gotten across the street and decided to call the police. So I think the fact that at least Holly followed him for a short distance is a factor the jurors considered.
Isn't that more a reaction suggesting that she was, she had misgivings about what had happened earlier, or she just, oh, shoot, this was a bad, I was in danger previously, as opposed to I'm now in danger of imminent harm. It seems like the reaction is more along those lines, that I was previously in danger and I didn't realize it.
I think the jurors could have drawn that inference, but I think it's just as reasonable, if not more reasonable, to infer that he was still attempting to dissuade them from following him, and she was actually in reasonable apprehension. Of course, you don't have to be in fear, you don't have to be afraid, you just have to reasonably apprehend the possibility of imminent physical harm. And I think clearly that was a question for the jurors.
Could I just change the hypothetical? If, let's say, a day previously, there'd just been an argument, somebody says, let's say it's the same defendant, that just says, I hate you, I want to kill you, but no gun pointing, but clearly an altercation, and he says, I want to kill you. So the next time they see him, he's walking away from them. Is there an aggravated assault as he's walking away holding a gun at his side?
Under those facts, I would say it's highly unlikely. I mean, obviously, depending on the circumstances, you know, you might argue that there, but I think given the fact that it's a remote incident, no. But here, and it's very important, I think, and the prosecutor pointed this out not only to the jurors, but in response to the motion for DV, we don't forget what happened immediately, seconds before he attempted to walk away. And he clearly attended to place them in reasonable apprehension. He had a gun. At this point, they know it. They can consider what just happened to determine whether they're in reasonable apprehension at that point, and the jurors can draw that inference.
Well, how does a defendant ever validly withdraw from committing the crime if he points the gun, intending to cause a reasonable apprehension, and then he thinks, oh, I should now do that, and then and he stops and turns and walks away. So does that intention follow? Is that issue done for?
Well, we have odd facts here. Obviously, you'd have to have the same scenario where the victims don't realize he's pointing a gun, but taking that as a given, the prosecutor pointed out there were other things he could have done here. He could have holstered the gun, tucked it in his pants, or apologized. He didn't do that. He tried to get away quickly. He kept the gun out, and the jurors could reasonably infer, based upon what he just did, he didn't want Leonard to retaliate, and he didn't want them, or he didn't want to be followed so that the police could be summoned to his apartment.
So it's all one event, and the intent occurred there, so it stays there, regardless of what he did immediately afterwards.
That's a jury question, right. And quite honestly, when I assigned myself this case, my first thought was to argue that, well, wait a minute, when he pointed the gun, he clearly intended to place them in reasonable apprehension. The fact he didn't at that second didn't matter. That, as long as they eventually were in reasonable apprehension, that was good enough. But given what the prosecutor argued in response to the motion for directed verdict and what he argued to the jurors, I didn't think in good faith I could argue that before this court. But that's why, as I said, the prosecutor really teed this up so we know precisely what all 12 jurors found.
So can you repeat for me what this theory of guilt was to the jury?
Yes, and I've quoted it extensively in my brief. The state's theory was that he pointed the gun at them. They, at that point, didn't know it was a gun or wasn't sure it was a gun, so they, at that point, were not in reasonable apprehension. After Holly began walking across the street and he apparently recognized her, he put the gun down and attempted to walk away. He walked in two separate directions. The state's theory was, at that point, he wanted to get away. His motive, so to speak, changed from having them leave, get out of my neighborhood, to now I got to get away for two reasons. One, Leonard might beat me up after we've had our altercation. Now he realizes that, I do have a gun. And two, he didn't want to be followed because he didn't want the police directed to his apartment. That was the state's theory. The state argued that to the jurors. And really, we have here a classic jury question. When you try to get in the mind of the defendant, you almost always have to do that through circumstantial evidence and by inference. And in resolving that issue, the jurors necessarily look at the conduct of the defendant before, during, and after the alleged crime, and it's up to them to draw any reasonable inferences from the evidence. Now, this court, or the members of this court, may not have found guilt beyond a reasonable doubt. That's not the standard. The standard is simply whether any reasonable juror could find guilt beyond a reasonable doubt.
Is there any evidence beyond the, I've pointed a gun previously, beyond, and it's certainly evidence, holding a gun at the side? There's no movement. It doesn't turn, no quick, sudden movement or some suggestion that he turns toward them? Is there anything more than I've pointed a gun previously?
As I recall, Leonard testified that he had put the gun down. We're not sure whether it was pointed straight down, but he put the gun down. He turned quickly one way, began walking, quickly turned back, I believe, towards them and walked the other way. According to Leonard, and he was intoxicated, he apparently began walking the wrong way, turned around and walked back. But there's no evidence that he pointed the gun at them. But of course, that's not a required element of the ag assault. He need only intend to place them in reasonable apprehension.
It doesn't have to be imminent physical
of imminent physical injury.
But that's my concern with it is how is it imminent if there's no movement towards them? They're afraid of him because they've seen they realize that he's pointed a gun at them previously, but now he's walking away from them. So what's the imminent?
The imminent is what exactly Leonard said. Is I thought he would turn around and shoot me. That's imminent. Again, the gun doesn't. It'd be more of a threat, or you would put more fright into the victims by actually pointing it, which he did initially. But he had the gun. The issue was what was in his mind at that time. Did he intend to continue to place them in reasonable apprehension so he could now get away and dissuade them from retaliating against him, or did he not have that intent? And again, that's really a classic jury question. And I haven't thoroughly researched this, but I can't think of any cases where a sufficiency claim was reversed on appeal dealing with the issue of intent. There may be a couple with premeditation, but that is almost always, if not always, a jury question. What was in the mind of the defendant when the alleged crime occurred? And that's exactly what we have here. And all 12 jurors, after the prosecutor teed it up for them, found he continued to intend to place them in reasonable apprehension. His motive for doing so may have changed from having them leave to having him make good his escape, but the intent was still there. And I'm not...
And he did that by not holstering or hiding the gun in some way. Is that...
I'm not suggesting that he had to do that, but that would certainly tend to negate, or certainly it'd be more difficult for the jurors to draw the inference that he still intended to place them in reasonable apprehension had he holstered it, put it in his belt, or even apologized, saying, "I'm sorry, I didn't realize it was you, Holly," or whatever. He doesn't have an obligation to do that, but we got to remember he wasn't dropped out of the air in this position. We have to look at everything that occurred previous, and when you do that, it's clearly a reasonable inference to find that he still, at that point, intended to place the victims in reasonable apprehension.
Well, assuming he wanted to place them in reasonable apprehension, I'm still having a hard time coming up with, at least as to Holly, what her fear of imminent harm. There's nothing that she said or did that suggests that she was anything other than I'm concerned about what happened previously. But there doesn't seem to be anything that suggests any fear of imminent physical harm on her part.
Well, admittedly, she never specifically testified to that, as did Leonard. But again, in just reading her testimony from a cold transcript, you get that, she says, "Oh my God, babe, it's a gun." And you get a feeling...
That's, "Oh my God, something happened in the past."
But it's continuing. It's continuing. We're not talking about separate incidents. There's a matter of seconds. This is a continuing event. The issue now becomes, was she still in reasonable apprehension when he had the gun down? And did he intend that she be in reasonable apprehension? And again, I think that's a classic jury question. The fact that she walked a short distance after him may not have shown great judgment, but it didn't negate the possibility that she was in reasonable apprehension of imminent physical injury.
She could be trying to diffuse the situation by pushing him, but still be in reasonable apprehension.
Yeah, I've had probably dozens of cases, usually alcohol's involved, where someone tries to diffuse a situation and they wind up being shot because they're trying to stop the defendant from doing something to someone else. So, and I'm not suggesting that this is the strongest case. I mean, it's a case I wouldn't want to try, I'll tell you that. But the only issue is whether any reasonable juror could draw that inference. And as I said, we know precisely what all 12 jurors found because the prosecutor teed it up for them. I'd like to briefly, unless the court has any questions on that, I'd like to briefly address the quote-unquote alternative argument, which I submit you don't need to reach. And that is if you find there's insufficient evidence that either one or both victims were placed in reasonable apprehension or that appellant did not intend to place them in reasonable apprehension after he lowered the gun, that the conviction should be reduced to attempt. And I cited, I think, a rule of procedure or a statute in State versus DeGaio in our brief. I've got some additional authority. I didn't file a supplemental authority, but because it was a backup argument. But
Counsel, what about the argument by defense counsel that it's waived? I mean, because most of the case law, or I don't know, Judge Howe referred to one possible case, but most of the case law seems to relate to where a lesser included was actually at play. It was at issue. Yeah, at issue.
And that's a situation where the state didn't request it, and there's some issue on it. Here, it was never requested by anyone. The issue becomes, does that preclude this court from reducing it to a necessarily included offense? And the answer is no. State versus DeGaio, I reread that before.
And why is it Did Julio?
I'm sorry,
Yes, and that was the trafficking of stolen property.
I'm not sure. I don't remember the facts because I just read the issue. But in reading that, there was no indication that any lesser included offense was requested. Also, 31.17D says when the appellate court finds that the evidence introduced at trial is not legally sufficient to establish the defendant's guilt of the offense of which he was convicted, but is legally sufficient to establish his guilt of a necessarily included offense, it may modify the judgment to one of conviction for the lesser offense and remand for resentencing. Also, State versus Gray, 227 Arizona at 429 paragraph 18. I've read that case, and it seems clear to me that there was no lesser included given to the jurors in that case. State versus George, 206 Arizona, 442 through 43, paragraph 14. Again, it appears in that case that there was no lesser included instruction given. And here, if the court were to conclude there's insufficient evidence of the charged offenses, the jurors necessarily convicted him of attempt because he did everything he could to place them in reasonable apprehension.
At the moment he pointed it
out. Right, but for the fact...
I understood your argument in the brief to be it's clear when he was pointing the gun.
Yes.
But the jurors were never really tasked with making that determination. They were asked to decide whether he intended it as he was walking away.
Right, but I don't think this is a situation such as State versus Cloaklick where you have two separate incidents. And in that case, there was a pointing of a gun from a car at another vehicle, then there was a chase, and there was another pointing of a gun, and the state argued, well, you can convict him for either. He had one defense to the first one, which is I didn't do it, a second defense to the other one, which is self-defense. This is a continuing offense, so I don't think it would matter in this situation whether that precise theory was argued to the jurors. Again, the state's theory was he intended to place them in reasonable apprehension throughout. His motive changed from get out of my neighborhood to now I got to get away. But he never stopped intending to place them in reasonable apprehension.
So what is the evidence of the timeline in this case for the duration of the event?
It's not clear, as you can imagine, when the victims testified, but it was clearly that this was continuing. There was the argument, he pulls the gun out, tells him to get away. There's the argument going back and forth between Leonard and the defendant. He apparently has the gun out the whole time based on their testimony. At some point he moves. Holly apparently thinks she may recognize him. He's still got the gun out, walks across the street. That's when he puts the gun down and tries to get away. So it's a continuing, there's no intervening events or no break in the chain of events here.
Are we talking minutes or seconds or that's obvious to us to do? I
think, and Mr. Dew said this, and I have no reason to doubt it, I think Leonard said like 5 minutes, but given witnesses are notoriously bad at judging time, I think 5 minutes would be an eternity in a situation like this. So it was probably substantially shorter than that. He relayed their discussion or their insults going back and forth. So it was a short period of time, but again, it was continuous. He had the gun out during that whole time. So it is a continuing event. I see that my time's expired. Unless the court has any questions, I'd ask that the court affirm the judgments of conviction and the sentences imposed by the trial court.
Thank you, counsel. Mr. Dew?
Thank you, Your Honor. There are reasonable inferences and unreasonable inferences from the evidence. And as a reviewing court and looking at the sufficiency, I think you're entitled to see something that is unreasonable. And Judge Gattani said it correctly. When he puts the gun down and starts to walk away, he doesn't go, there's no evidence of this, and don't you follow me, and don't you call the police, and not even pointing, don't you better not follow me, you better not call the police, you better not do anything. That's a little bit something different than what the prosecutor was saying. At the trial itself, this whole bit about what the prosecutor would rely on only came about because of the Rule 20 discussion. The state's case in chief, he was relying on that. After Judge Martin almost granted the DV, the prosecutor said, well, look, he was still in apprehension because they were afraid to follow him and they thought he was going to shoot him. And Judge Martin said, okay, I can buy that. So now the prosecutor, in final argument, makes that argument. But that wasn't the theory of the case in the state's case in chief. And as to whether or not they were still apprehensive, I think anyone seeing a guy walk away with a gun is going to be apprehensive about trying to follow him. I certainly wouldn't go tackle somebody with a gun if I were unarmed. That's not the kind of apprehension that he's intentionally placing them in. They are just scared because he's got a gun. And what they thought he did before, what they now found out he did. So they're not going to follow him. And it's not like he intended them, like, if you want some more of that, you better come on, or, that kind of thing. There's no facts on that. There's nothing at all. That is, in my opinion, an unreasonable inference from the evidence, and that's all the prosecutor could hang his hat on at the end.
The timing of all this, I think, is important. If it's several minutes, I might be more sympathetic to your argument. If it's a matter of seconds or a minute, then it's hard to parse that out and say that once he stops pointing the gun, the crime is over with.
Well, I agree with you there. The problem I have is the female goes, hey, I'm blah, blah, blah. Or Dan, I'm blah, blah, blah. I live next to you. Or something. I forgot what she said. Something like, hey, we know each other. What is this? Oh, and then he walks away. All right. That situation is diffused. Now, someone chasing a man with a gun who's probably drunk because of the 5-minute exchange is not a very good idea, and I think all of us would be apprehensive about doing that. But his walking away does not place me in apprehension that I'm going to be shot. If I chase him and tackle him, I'm going to be in real apprehension I'm going to be shot. So I think that to say that he was still placing them in apprehension as he's walking away is just simply an unreasonable inference from what the evidence was at trial.
Well, if that's the case, then why do you concede that the elements of the lesser have been satisfied?
The lesser ones would be satisfied because of the actual pointing. There's circumstantial evidence he had a gun in his hand and was pointing it. He was pointing something, and he had a gun in his side later. That's circumstantial evidence he was pointing a gun. All the elements he obviously intended to do because he was telling him, get away from the girl. Okay?
But isn't that something that's not really charged? He wasn't charged with intending to put them in harm, or that's not what the jurors were charged with.
Well, they were only instructed that he intentionally placed them in reasonable apprehension. It was not knowingly. It was just an intentional apprehension that he placed them in.
But isn't the only thing the jurors have decided is as he's walking away, he's intending to put them in harm?
Who knows what jurors decide? I know that was the argument that was made.
That's what the state's argument, the whole theory of the case was, he's putting them in fear.
He's continuing to put them in reasonable apprehension, I think.
So I have a hard time relying necessarily on the he pointed the gun at them previously, but when he doesn't put the gun away completely, again, agreeing that it's a weak case, but they do have in their mind, they know that he's threatened them in the past. and he's not putting the gun away. So it's, even if it's just kind of holding it, if he'd holstered it, then it seems like it's an almost impossible argument to make. But if he's not putting it away, there's still arguably some chance that he's going to turn and shoot them.
Well, where would he put the gun, Judge? I don't think there were any facts that he had a holster on. I mean, when you have a gun in your hand, where do you put it? You know, I guess you could put it in your pants, and Mexican carry.
You put it in your pocket, put it in your waistband, and just throw it away.
I don't know if you could put a gun of this type in your pocket. I think it'd be a little difficult without it falling out.
But presumably he didn't come there, he didn't arrive with it just in his hand. He doesn't just walk around town.
We don't know that, Judge. We don't know that.
Well, if he really wants to no longer put them in fear.
Well, I guess he could put it on the ground and walk away, but that's kind of like the movies when the police say put it on the ground and walk away, that kind of thing. Once again, we don't have any evidence that he was continuing to threaten them as he's walking away. You better not chase me. If you know what's good for me, you better not call the police. I know where you live. I know who you are. That kind of stuff.
Well, the state's argument, at least today, is that it's continuing. That we all agree that he intended to place them in reasonable apprehension when you pointed the gun.
Yes, sir.
The state's theory today seems to be that carries forward. Your argument must be, I take it, that once he no longer is pointing them, then the crime has ended. Then.
Because he's no longer intending to place them in reasonable apprehension. As long as he intends to place them in reasonable apprehension, I guess it could go on forever. He could sit there and hold the gun at him as he's walking away to the apartment to escape, as the prosecutor said. But he's not doing that. So there's no intent that's commensurate with their subjective apprehension.
Does he have to point at them? Can he just wave it as he's walking away?
Well, that's different. That's what I said earlier. If he's waving at you, better not follow me. Don't call the police if you know it's good for you, because I'll come back and get you. That kind of thing. Sure. You betcha. That's a continuing episode. We don't have any facts for that. That's why what I say is an unreasonable inference. It just doesn't come from those facts. Thank you.
Thank you, counsel. Thank you for your argument. We'll take this matter under advisement and we'll issue a decision in due course. We stand adjourned.